What's up, Trojan fans? Lizelle Brandt here at the USC Gould School of Law. I am excited to be debuting a new series for WeAreSC, and that is the Trojan Law Blitz, where I talk legal issues in Trojan sports. First up, we have Todd McNair versus the NCAA. What's going on between those two anyway? A play-by-play is in order. When the NCAA hit USC with sanctions related to Reggie Bush, they also made findings in regards to former Trojan running backs coach Todd McNair. And what their findings said was that McNair had known about violations and also that he had lied about it. Now, how the NCAA came to this conclusion is a little bit of a mystery because a lot of what the NCAA does is kept under seal. In addition to the penalties that were imposed on USC, Coach McNair was issued with some penalties by the NCAA, which basically prevented him from contacting football recruits for the period of a year. And McNair tried to appeal the decision of the NCAA through the NCAA's own appeals process, but he lost. Because of this show cause penalty, it pretty much killed his career because he was not able to find a job after. After that, McNair decided to hire the Big Guns, which is a plaintiff's law firm of Green Broilette. Very, very well known in the legal community. Nearly a year after the sanctions were imposed on McNair, Green Broilette, on behalf of him, filed a lawsuit against the NCAA. McNair's lawsuit alleges 7 causes of action, including the defamation claims of libel and slander, tortious interference with economic advantage, tortious interference with contractual relations, breach of contract, negligence, and declaratory relief. And the damages that he is seeking is unspecified damages, which is pretty typical in a situation like this. Now, McNair is not the only one who hired Big Guns to handle this lawsuit. The NCAA hired Loeb & Loeb, a law firm which is also pretty big and well known in the legal community. The NCAA filed a special motion to strike, an anti-SLAPP motion, which is a strategic lawsuit against public participation. What this is basically saying in English is that the NCAA was challenging McNair's filing of his lawsuit and his claims because the NCAA claimed that McNair's claims arise out of the NCAA's performance of behavior that was completely privileged, and that it was behavior that arose out of its official proceedings in regards to investigating the McNair and Reggie Bush matters. Special motions to strike are one way that defendants can get lawsuits kicked out because in effect it says, hey judge, we're exercising our First Amendment rights, we've got clear privilege, complete privilege to do what it is that we're doing, so please throw this case out, and by the way, give us our attorney's fees back. Now, one of the ways that McNair can continue with his lawsuit despite this anti-SLAPP challenge is if McNair can prove that the NCAA committed malice in its acts that it believes are protected. In addition to the anti-SLAPP motion, the NCAA also filed a motion to keep all of its records under seal. What's interesting to note is that initially, this motion to seal was not really opposed by McNair. This all came before Judge Schaller in November of 2012, where he made 2 findings. The first is that McNair could proceed in the merits of its case because he believed that the anti-SLAPP motion failed. And the way that he found this was he believed that malice was shown by the NCAA, which would allow McNair to move forward in his case. The second thing that the judge found was that the records the NCAA wanted to seal were of such public interest that he believed that they should be unsealed. The NCAA decided that it was going to appeal or challenge the ruling of Judge Schaller. And the way that it needed to do that was to kind of go above him to the Court of Appeals, the 2nd District here in California, to review the decision of the judge. What this in effect did was it put a stay on the action, which is kind of like a timeout, putting the case completely on hold while the higher court, the Court of Appeals, made a decision on whether or not Judge Schaller was correct in ruling that McNair could proceed in the merits of his case by denying the anti-SLAPP motion, and also whether or not the NCAA records should be sealed. Now, with the case in front of the Court of Appeals 2nd District and the Court of Appeals deciding, number 1, whether or not McNair can proceed with his lawsuit, and number 2, whether the NCAA records could be sealed, in comes a third party, a non-party, the Los Angeles Times and the New York Times, or the media, which filed an intervening application to challenge whether or not the records should be sealed. What they wanted is for the records to be unsealed, claiming that the public has a right to know. That'll do it for us here at the Trojan Law Blitz. If there are any topics that you want us to cover, you can email me at lizelle@singjinlaw.com or tweet me to Lizelle Brandt. If you like this video, make sure you subscribe to this channel, and for even more on your USC Trojans, visit www.wearesc.com. At the USC Gould School of Law, I'm Lizelle Brandt. You're watching WeAreSC.